Question 861. A loan using real estate as security and not relying on insuring or guaranteeing the loan is called a conventional loan, b. conforming loan, c. VA loan, d. FHA loan. Correct answer is a conventional loan. Conventional loan is a type of mortgage loan that is not insured or guaranteed by any government agency, like FHA or VA. It relies solely on the borrower's creditworthiness and the collateral, the real estate, for security. This matches the description perfectly. A conforming loan is a type of conventional loan that meets the guidelines set by Fannie Mae and Freddie Mac. While it fits the not insured, guaranteed criteria, conventional loan is the broader category directly defined by that absence of government backing. VA loan is guaranteed by the U.S. Department of Veterans Affairs. FHA loan is insured by the Federal Housing Administration. Therefore, the loan that fits the description is a conventional loan. Question 862. All of the following buy loans on the secondary mortgage market, except a. Fannie Mae, b. Freddie Mac, c. FHA, d. Ginnie Mae. Correct answer is C. FHA. The secondary mortgage market is where existing mortgages and mortgage-backed securities, MBS, are bought and sold, providing liquidity to primary lenders. Fannie Mae, Federal National Mortgage Association, a government-sponsored enterprise, GSE, that is a major participant in the secondary mortgage market. It buys conventional, FHA, and VA loans from lenders, packages them into MBS, and sells them to investors. Freddie Mac, Federal Home Loan Mortgage Corporation, also a government-sponsored enterprise, GSE, that functions similarly to Fannie Mae. It buys conventional, FHA, and VA loans from smaller banks and thrifts, securitizes them, and sells them to investors. FHA, Federal Housing Administration, is an agency within HUD that insures mortgage loans made by approved lenders. It does not buy or sell loans on the secondary market. Instead, its role is to protect lenders from losses in case of borrower default on FHA-approved loans, thereby encouraging lenders to offer loans to a broader range of borrowers. Ginnie Mae, Government National Mortgage Association, is a government corporation. Ginnie Mae guarantees mortgage-backed securities, MBS, composed of FHA, VA, and USDA loans. While it doesn't buy the loans themselves, its guarantee makes these MBS attractive to investors on the secondary market, indirectly facilitating the flow of capital. Therefore, the entity that does not buy loans on the secondary mortgage market is the FHA. Question 863. An option agreement must include a term stating the a. offer will remain open indefinitely, b. offer will remain open for a definite time period, c. offeree can assign the offer to another party, d. offeror can revoke the option offer at any time. Correct answer is b. offer will remain open for a definite time period. An option agreement is a contract that gives the option holder the right to buy or lease a property at a predetermined price within a specific time frame. The option period is a crucial element of the agreement, as it defines the window of opportunity for the option holder to exercise their right. The optionee pays for the right to decide whether or not to buy within a clearly specified period, e.g., 30 days, 6 months, 1 year. Without a definite time frame, the agreement lacks certainty and would likely be unenforceable. An option cannot remain open indefinitely. It must have a defined expiration. While many options are assignable, meaning the optionee can transfer their right to another party, assignability is not a required element for an option's validity. It's a common feature but not essential for its creation. The entire point of an option is that the offeror, owner, cannot revoke the offer during the specified time period, provided the optionee has paid consideration. If the offeror could revoke it, it would not be a true option. Question 864. A property may lose its homestead status if A. Homestead owner builds another property. B. Homestead owner moves out of state. C. Homestead owner records another homestead. D. Homestead property is destroyed in a flood. Correct answer is C. Homestead owner records another homestead. A property may lose its homestead status if the owner ceases to use it as their primary residence, or if they take formal action to claim a new homestead. Simply building another property doesn't automatically terminate the homestead on the existing one. Unless the owner moves into the new property and establishes it as their new principal residence. If the owner moves out of state and establishes a new principal residence there, the California property would cease to be their primary dwelling. Since homestead protection applies only to a principal residence, moving out and establishing residency elsewhere would cause the California property to lose its homestead status. Homestead owner records another homestead. This is a definitive legal act that causes the loss of the previous homestead. In California, a homeowner can only have one declared homestead exemption at a time. If a new declaration of homestead is recorded for a different property, the previous homestead is automatically abandoned by operation of law. California Code of Civil Procedure Section 704.990a. The physical destruction of the structure does not necessarily remove the homestead status from the underlying land and any remaining equity. Especially if the owner intends to rebuild or it remains their primary residence location. Both B and C can lead to the loss of homestead status. However, C, homestead owner records another homestead, is the most direct and legally explicit action. That definitively terminates a prior homestead, as it's an action taken by the owner that automatically abandons the previous claim. The final answer is C. Question 865. A rider in a contract would be an A. Acceleration clause. B. Amendment. C. Encroachment. D. Donny. Correct answer is B. Amendment. Acceleration clause is a specific provision within a loan contract, not a separate attachment. Encroachment is a real estate term referring to an intrusion onto another's property, not a contractual element. Donny is a party who receives a gift or bequest, not a contractual component. In a contract, a rider is essentially an attachment or an addendum that modifies, clarifies, or adds to the terms and conditions of the original agreement. Therefore, a rider in a contract would be an amendment. Question 866. The legal basis for federal fair housing laws comes from the A. Fair Housing Code stated in the Emancipation Proclamation. B. Bill of Rights in the U.S. Constitution. C. Civil Rights Act of 1866. D. The law establishing the Department of Housing and Urban Development. Correct answer is C. Civil Rights Act of 1866. The legal basis for federal fair housing laws primarily stems from the Civil Rights Act of 1866. This act was the first federal law to prohibit racial discrimination in the sale and rental of real and personal property. Although it was largely overlooked for many years, the Supreme Court's ruling in Jones v. Alfred H. Mayer Company, 1968, affirmed its power, making it a crucial foundation for subsequent fair housing legislation. The Civil Rights Act of 1866 initially established legal protections against racial discrimination in housing. Later, the more comprehensive Fair Housing Act of 1968 significantly expanded these protections to prohibit discrimination. Question 867. A court-issued writ of possession provides a landlord with the right to have the sheriff remove a from a rental unit. The deadline for the tenant to leave voluntarily is A. 24 hours. B. 5 days. C. A week. D. There is no grace period, the tenant must leave immediately. Correct answer is B. 5 days. In California, once a court issues a writ of possession, after an unlawful detainer lawsuit, the landlord provides this writ to the county sheriff. The sheriff then posts a notice to vacate on the tenant's door, which includes the writ. The deadline for the tenant to leave voluntarily after the sheriff posts this notice is typically 5 days. This 5-day period allows the tenant to move out before the sheriff returns to physically remove them from the rental unit. If the tenant does not leave by the end of the 5th day, the sheriff physically remove and lock the tenant out, and seize any belongings left in the rental property. The landlord cannot take possession of the property until the tenant is removed. Question 868. A veteran qualifying for a CalVet loan must pay the following fees, except A. Discount points, B. Appraisal, C. Origination, D. There are no fees for qualified veterans to obtain a CalVet loan. Correct answer is A. Discount points. A veteran qualifying for a CalVet loan must pay fees such as an application fee, appraisal fee, and origination fees. However, they are not required to pay discount points. The property is purchased by the Department of Veterans Affairs and then sold back to the qualifying veteran through a land contract. Question 869. To qualify for an FHA reverse mortgage loan, a borrower should be A. At least 62 years old, B. Own and occupy the property subject to the loan as a principal residence, C. Join a special FHA consumer information session, D. All of the above. Correct answer is D. All of the above. An FHA reverse mortgage, also known as a HECM, allows homeowners aged 62 and older to convert their home equity into cash. This loan doesn't require monthly payments. Instead, the balance grows over time. The loan is repaid when the homeowner sells the home, moves out permanently, or passes away. The FHA insures these loans, providing security for both the borrower and the lender. To qualify for an FHA reverse mortgage loan, a borrower must meet the following criteria. A. The borrower, or one spouse, must be at least 62 years old. B. The borrower must own and occupy the property as their primary residence. C. The borrower must attend a HUD-approved counseling session to understand the terms and implications of a reverse mortgage. This ensures they understand the loan's terms, obligations, and implications. Question 870. All of the following are contracts, except A. Quitclaim deed, B. Title report, C. Net listing, D. Both A and B. Correct answer is D. Both A and B. A quitclaim deed is a legal instrument used to transfer any interest a grantor may have in real property to a grantee. It's a document of conveyance that transfers existing ownership interests. It's not a contract that establishes mutual obligations or agreements for future actions between parties. While it stems from a prior contract, like a purchase agreement, the deed itself is the execution of that transfer. A title report is an informational document prepared by a title company or abstractor. It provides a summary of the property's legal history, including ownership, easements, liens, and other encumbrances. It is a report or statement of facts, not an agreement between parties. A net listing is a type of listing agreement, which is a contract between a property owner and a real estate broker. In this agreement, the seller sets a net price they want to receive, and the broker's commission is any amount the sale price exceeds that net figure. This clearly fits the definition of a contract, as it involves an offer, acceptance, consideration, and creates mutual obligations. Since both a quitclaim deed and a title report are not contracts, the correct answer is D. Both A and B.